Hey everybody, today's legal question is whether or not a child who's a joint tenant can live in the home after the parent passes away. The answer to this in just a moment, and it really comes down to a definition. Before we get there, I want you to imagine a friend going through a what if scenario that creeped into their lives suddenly. But they were fully prepared because you shared this video. We would appreciate it, as will your friend. I'm Valerie Zammitti, an estate planning attorney in New York and New Jersey, and we're here to educate everyone for free. So we would like you to drop your questions so that hopefully together we can help others before something happens in their life. Now, this question does come down to how you define joint tenants. There are joint tenants with right of survivorship, and this means that both parties own 100% of the property. The death of one of the parties does not change the 100% ownership that each individual has. And so the surviving person may utilize the entire property at that time. This is very typical when a husband and wife, or married couple, I should say, purchase a property. They have the property, it's in some states called tenants by the entirety as opposed to right of survivorship, but it means the same thing. If you are not a married couple and you want and intend your ownership in the home to be that, you have to specify under the deed and the title that it's with right of survivorship. Now, some states, even with a currently married couple, if the property was not purchased while they were married, it would be treated differently, just as any non-married couple who purchase a property, unless it's specified, will get treated as if they owned it in separate interests, which we call tenants in common. This happened recently with a married couple who had purchased their home before they were married. It was a second marriage. Our client, the wife, in her late 80s, 90s, lost her husband, and we wound up having to probate 50% interest in her home, where the deceased husband's other children from his prior relationship, had a right to 50% or a portion of the home at that time. And they wound up settling, and the surviving spouse had to pay some monies to the children for that 50% portion in her home. Now, this tenants in common, again, in general, means a separate interests of individuals. And so the right to live there, if you have a separate interest, depends on who receives the interest from the deceased owner. Last comment on tenants in common, it does not have to be a 50-50 division. It can be other percentages, 10-90, 20-80, what have you. And that occurs sometimes when one party provides a certain amount towards the purchase of a property and the other provides more or less. So we hope this information was very useful to you and or a friend, and that you've learned something new today and choose to share. As always from us, please take care.